is entitled Environmental Justice in Maryland, How Recent Changes to State Law Impact Equity. Please, we're going to have time for questions. If you could hold them to the end, that'd be appreciated. For everybody tuning in online, go ahead and put them in that Q&A box. Our first panelist, we've got Assistant Secretary at the Maryland Department of the Environment, Devin Dodson. Thank you for joining us, Devin. Devin's full and impressive bio is on our website, accessible by that QR code. We've also got two student attorneys from the Maryland Carey Law Environmental Law Clinic. We've got Margaret Bushko and Cody Coulter. I'm going to let these guys take it away, so thank you very much.
Oh, my, oh, there we go. Thanks. Good morning, everyone. I'm Assistant Secretary at the Maryland Department of the Environment. If you go onto that QR code and look at my bio, it looks a whole lot more impressive when you got it written down like that than it really felt like doing it all. So I'm here to talk about environmental justice and some new activities and actions that took place. I'm gonna tell you a little story, try to make it very quick. This an effort that MDE has been spearheading in leading the state agencies going forward on diversity, equity, inclusion, and justice kind of fell into my lap. So at the time I was working for then Secretary Ben Grumbles as his senior advisor on energy policy. And we had a situation where a community in Prince George's County, the Brandywine communities, sued the Maryland Department of the Environment, sued the Department of Natural Resources Power Plant Research Program, and sued the Public Service Commission for improperly placing a gas-fired power plant in a community with environmental justice concerns. And turns out there was nothing the state could do because all of the laws had been followed. The reason why this community was up in arms was because the developer for the gas plant had a public participation element. He has to go and talk to the community where the plant's going. So at this public participation hearing, the developer brought in several community members from Brandywine who were supportive of the power plant coming in. Turns out those residents of Brandywine were 10 miles or further from the power plant. The residents that were within we call the front line of that power plant were never notified about the power plant's existence until the construction started. Anyway, MDE and the other agencies, because our actions were legal, there was nothing that EPA could do. But what EPA has to do a mediation between MDE and the community where we could give them prospective relief, i.e. Enhance and change our public participation processes, et cetera. Community at the end of the day did not sign that agreement because there was no resources, no money associated with it. But at the same time this is happening, that was 2.5 years of my life, Freddie Gray happens, George Floyd happens. And we start taking these issues of diversity, equity, and justice and looking at them through a new lens. So here's the definition of environmental justice straight off from EPA. And then Maryland builds on that definition, adding that citizens should expect to be protected from public health hazards and have access to socioeconomic resources necessary to address those concerns. So what are we doing? We created an internal EJ policy in 2020. My former boss, Ben Grumbles, said to me, please, we've got to revitalize this agency vis-a-vis justice, diversity, equity, and inclusion. And so you'll have the slides. I don't need the slides. I don't use the slides really. I'm just talking through them. We also have a Commission on Environmental Justice and Sustainable Communities. That commission had been criticized because it had been inactive. We had languishing members. My secretary told me to revitalize that commission, and we did. And that commission is one of the strongest entities that we have in the state. Our Environmental Justice Commission is statewide, and it holds agencies' feet to the fire, state agencies' feet to the fire. But now it's going to start holding counties and localities' feet to the fire as well, because many of these issues can be addressed early in the local scene. We talked about the EJ screening tool. So the reason why we ended up creating an EJ screening tool, now EPA has an EJ screening tool, right? University of Maryland already has an EJ screening tool. Why did MDE create its own screening tool? The reason we did that was not just because we had MDE specific information that we could use. It was also done by a working group that was created by that internal EJ policy that we've created. That working group was made up of from top to bottom throughout our agency. So the reason I wanted that EJ screening tool created was to get buy-in in my agency for turning us around with dealing with equity, diversity, inclusion, and justice. And it worked because now everyone in the agency knows about the screening tool and is using the screening tool for their own work. Not what's statutorily required yet, but for their own work. And we're going to talk about what's statutorily required in just a second. So we create this screening tool, soup to nuts, and it's fantastic. The beauty of this screening tool now is that it mirrors what was happening in law. So while we were creating the screening tool, the legislature meets and starts talking about diversity, equity, and justice and issues. So what the legislature ended up doing was pass two bills that significantly affected environmental justice. So I'm going to weave back to the screening tool in just a second. The Climate Solutions Now Act. So that's the big comprehensive bill that now requires us to reach 60% greenhouse gas reductions by 2031. But in that bill, there's a section in that bill that describes something that the department has to do with our Commission on Environmental Justice in doing climate change research and climate change impacts. But the beauty of what the legislature did here was, for the first time in state law, they defined two very important terms for environmental justice. First was underserved community. Now we have a definition in state law of an underserved community. And an underserved community is a community where any census tract has 25% or more poverty, 50% more minority, or 15% or more limited English proficiency. So when you go back to that map, when we did the screening tool, the way we coded the map is color coded in yellows and blues. And the darker the blue, the more underserved or overburdened your community is, right? So as soon as you click on the map, you go to our website, you click on the map, it populates a bunch of blues. Those blues are the definitions for underserved community. So if you go and look at that map, and why this is important, you can't really see it that well, but obviously in the I-95 corridor, you've got a lot of blues, right? But look at the shore. Look at all along the Delaware border of the shore, also blues. Those blues, some of them, yes, are minority. A lot of them are poverty. Take a look out in Western Maryland, out in Garrett County. See some blues. None of those blues are minority. They're all poverty. And that is why that map is so important, because you see in your state where all the spots are, where all the places we need to focus our attention. And so the legislature created that definition, we added it to our map, and now we're using it. How are we using it? Oh, sorry, let me go right back. So that's the definition of overburdened community. So for what the purposes of what my agency is doing vis-a-vis diversity, equity, inclusion, and justice, we are targeting those communities that are both overburdened and underserved. Overburdened community defined in state law now means any census tract where 3 or more of these environmental health indicators are at or above 75 percentile statewide. So my favorite one that I always point out in a meeting, and is very relevant here, proximity to a concentrated animal feeding operation, CAFO, is a environmental health indicator that triggers your community to potentially be overburdened. So you get 3 of those at 75% or more. You can imagine, if you look at the map, there's probably going to be a lot of places with 3 or more of those at 75% plus, because you got to be overburdened and underserved. In addition, with one of the poverty, minority, or limited English proficiency slots. So What does all that mean legally for the department? House Bill 1200 was passed. House Bill 1200 requires applicants for MDE's public participation permits, 1-601 permits, most of our air permits, about 3/4 of our land management permits, about half to 2/3 of our permits, all have a public participation, public notification element. So now that applicant for one of those permits must provide MDE with everything else that they have in the application. They have to do an EJ score. They run an EJ screen using our screening tool at University of Maryland and provide that summary sheet that comes along with our screening tool to show the EJ score for that community itself, for the address of where that proposed plant or permit is going to be. But it also shows what else is there, what other stuff is there, right? So this other stuff is the important things because we want to know exactly what is in and around that proposed area. And that's what the legislature wanted to do. So once the applicant provides that score to us, that screening score to us, we review it, verify it, most likely using our own screening tool. Make sure, and then we provide both of those, what the applicant has provided, considering that if it's accurate or not, and then our score. And then we provide that to the public when we provide public documents. That's it. That's all the law requires us to do. The legislature, when it passed this bill, wanted transparency and openness for those communities with concerns, with EJ concerns. And that is why they wanted the public notification part of it. But my agency would be doing a disservice to those communities if we left it at that. So my agency, what we now do, and this bill became effective October, we've gotten about 3 or 4 permits now. We are now doing what the law requires us. And that permit writer goes to his or her supervisor and says, hey, I know we can't deny this permit based upon an EJ score, but look at what's there. Is there some conditions, some modifications we could do to the permit to help that community? Because look at what's there. And that's what I wanted. It's the holy grail. It's the big win, because I've got people in my agency now thinking project by project, community by community, about diversity, equity, inclusion, and justice in their work. And it, as I told my boss years ago when we started this process, we win if that happens, if our agency is being more diligent about what goes into these communities. So what else are we doing? We're also targeting these communities using our EJ score and our EJ map. We've worked in Cheverly in Prince George's County. We're at Curtis Bay right now in Baltimore City. We're going to Turner Station in Baltimore City, Baltimore County as our next targeted enforcement, inspections, compliance, but also investments. These communities have been underserved for decades. A lot of federal dollars coming in. There are a lot of state dollars designed for diversity, equity, justice, and inclusion. And we're trying to target these communities. And we're not just staying on this side of the shore. We're over in the eastern part of the state as well. We're out in Western Maryland as well. Really trying to get our heads around what we can do to promote diversity, equity, inclusion, and justice in these communities. And I think that's my last slide. Oh no, one more. Couple other bills I'll mention just briefly. There's such thing as a supplemental environmental project. So rather than us finding a developer, finding a permit violator, we have what's called a supplemental environmental project database. So rather than us finding them, they give us money to the general fund. It goes wherever it goes. Targeted projects in those communities to better those communities. So if you violate in community X, your benefit, your violation, your penalty will go to that community as well. And then there is a Conservation Finance Act, which requires now my agency to work with our Environmental Justice Commission to make sure that Flint, Michigan doesn't happen here, to make sure that Baltimore City doesn't happen anymore. And that's who I am, and that's where you can reach me. Thank you very much. Happy to answer questions at the end. Thanks.
Let's wait for. Okay, perfect. Excellent. Well, thank you so much, Devin. In addition to Maryland's environmental justice permitting bill that Devin just discussed, other states have been passing environmental justice-oriented laws pertaining to both permitting and other aspects of environmental justice, or EJ, implementation, such as grants and enforcement. Nationwide, in 2021 alone, state legislatures considered at least 150 bills related to environmental justice. Sorry, so, okay. Can continue with that. No, I'll continue. All right. So I'd like to walk through a few of the recently enacted laws and their implications in New Jersey, New York, and Virginia in order to offer some broader context regarding environmental justice legislation elsewhere in our region. My hope is that by comparing just a few of these laws, I can provide a window into some of the trends in state level approaches to environmental justice, such as the formation of advisory committees, legislative declarations of environmental justice as a state priority, and increased participation and transparency. Cody will then offer some insight into the ways in which recently enacted laws in Maryland addressing a range of issues, including agriculture, infrastructure, food resiliency, also intersect with environmental justice matters. At the state level, New Jersey is commonly considered to be at the forefront of EJ legislation. In 2020, the governor signed New Jersey's environmental justice law, which, akin to Maryland's HB 1200 as presented by Devin, requires the New Jersey Department of Environmental Protection to evaluate the environmental and public health impacts of certain facilities on overburdened communities when reviewing permit applications. That evaluation is based upon publicly available data assessing the location of the state's most vulnerable communities. New Jersey's Department of Environmental Protection is currently in the process of promulgating regulations to implement the EJ law. And in the meantime, the department has issued an administrative order directing permit applicants to engage with overburdened communities and address concerns in a way that upholds the spirit of the EJ law to the greatest extent possible. New Jersey's EJ law declares not only the fundamental principle of environmental justice, that no community should bear a disproportionate share of the adverse environmental and health consequences of economic growth, but also that the state's overburdened communities must have a meaningful opportunity to participate in permitting decisions for facilities that may increase environmental and health stressors. The law requires the Department of Environmental Protection, or DEP, to evaluate the environmental and health impacts of 8 specific types of facilities, including major sources of air pollution as defined by the Clean Air Act, sewage treatment plants, landfills, and medical waste incinerators. The EJ law relies fundamentally upon the New Jersey DEP maintaining a list of overburdened communities in the state. New Jersey classifies overburdened communities based upon census data for 3 key factors akin to Maryland's criteria for underserved communities. And those are whether at least 35% of the households qualify as low income, whether at least 40% of the residents identify as a minority or a tribal community member, and whether at least 40% of the households have limited English proficiency. The state has launched a beta version of a mapping tool for permit applicants to assess all of this data in one place. If a permit applicant is hoping to build a new facility or expand an existing facility that will be located in an overburdened community, the applicant has to take 2 key steps: prepare an EJ impact statement and organize and lead a public hearing in the overburdened community. After those two steps are taken, if the DEP determines that the permit activities will cause or contribute to adverse cumulative environmental and health impacts on overburdened communities, the DEP will take a harder look at the permit request and potentially apply conditions to the permit to prevent those negative stressors on the environment or public health, as Devin described. It's so definitely something of a win for mitigating those adverse environmental impacts. New Jersey's law also goes as far as to mandate the denial of a permit if an EJ analysis determines that a new facility cannot avoid causing or contributing to disproportionately adverse cumulative impacts on overburdened communities, except in rare cases in which the department determines that a new facility will serve a vital public interest in the community in which it will be located. So this is really a very narrow exception, only granted if the facility serves an essential environmental, health, or safety need for the overburdened community, and there's no other way to meet that need. So for example, a wastewater treatment plant that serves the local community. Something unique about this is that under New Jersey's, the DEP's proposed regulations, the economic benefits of the proposed facility cannot be considered in determining whether a facility serves a compelling public interest. So the department will only consider public interest to mean environmental, health, and safety needs of the local community. So as I mentioned, the DEP in New Jersey is currently in the process of implementing its regulations and will likely continue to refine and adjust its rules as it works with regulated industry to ensure the protection of communities already experiencing the negative impacts of air and water pollution and other environmental and public health stressors. Over in New York, we can do the next slide. The state has also been active in implementing EJ legislation. New York recently passed 2 significant laws with environmental justice provisions. Environmental justice was included in its Climate Leadership and Community Protection Act, which created a climate justice working group that would establish criteria to identify disadvantaged communities for the purpose of climate protection related actions, like reductions in greenhouse gas emissions. The goal there is to ensure that underserved communities benefit from the state's initiative to transition to cleaner energy sources and in turn benefit from reduced pollution and cleaner air in their community. New York also recently passed Article 48 of its environmental conservation law, focused entirely on EJ. It established a permanent environmental justice advisory group and an EJ interagency working council, which includes members both of community-based organizations who work with minority and low-income communities on environmental matters, and representatives of businesses that are permit holders. The law requires each state agency that engages in any activities that have a significant effect on the environment to adopt and rely upon an EJ policy. So this includes agency actions like issuing permits, but also acquiring and maintaining property and funding certain projects. Policy-wise, this approach is longstanding in New York. The first mention of EJ in New York statutes was back in 2003, when EJ was added to the list of factors for the New York Department of Environmental Conservation, or DEC, to consider in selecting remedial actions for contaminated, abandoned industrial sites. That same year, the Commissioner of New York's DEC issued comprehensive guidance for incorporating EJ concerns into the DEC's environmental permit review process, as well as its enforcement, its grants, and its public participation. The policy had a number of elements that foreshadowed what I've described as far as New Jersey's EJ law and what Devin described as happening here in Maryland. It outlined the types of major projects and major modifications for permits that the policy would apply to. And then it required a preliminary screening to identify whether the proposed action was in or near a potential EJ area and would potentially have adverse environmental effects on the area. If so, guidance on EJ would be given to the permit applicants, and an enhanced public participation plan would be initiated as part of the permit process. And this policy is still actively in place today. So all this is to say, well, there's certainly been increased EJ activity in the New York legislature the past few years. It's also been integrated into departmental policy for the past 2 decades. Environmental justice nearby here in Virginia, meanwhile, has been touched upon in an executive order and a circuit court case, as well as addressed in legislation. Virginia recently implemented a broad Environmental Justice Act, establishing the promotion of EJ as a focus throughout the state. Virginia's established a state office of environmental justice, a council on environmental justice, and an interagency working group. As far as the intersection of permitting and EJ in Virginia, a 2018 executive order acknowledged that Virginians in low income and minority communities throughout the state, quote, do not enjoy clean air and water, in order to review of the State Department of Environmental Quality's permitting, monitoring, and enforcement activities. The executive order also called for improved communication, both with the public and with the regulated community. In Virginia, the development of EJ law and policy has been centered around a court case as much as legislation. In the 2020 case, Friends of Buckingham v. State Air Pollution Control Board, the Federal Circuit Court critiqued the Air Board's failure to consider the impact of a natural gas compressor station on local EJ communities. The court noted that environmental justice is not merely a box to be checked, and vacated the board's award of a permit for construction. So that key court decision has helped build momentum behind the legislation that's been enacted in Virginia over the past couple of years. So ultimately, while states vary in terms of whether EJ has been integrated into agency actions through policy or law or regulation, there are these common threads: the establishment of advisory councils and working groups that further EJ as a priority, a call to take EJ into account when state agencies conduct permitting and conduct permitting and environmental reviews, and also a call for greater public participation and communication with those overburdened communities. A number of legislatures have designed bills aimed at empowering the agency and the public with tools to make their work more equitable and to inform both proponents and opponents of the process. Environmental justice can only be achieved when all communities have that same level of protection from environmental and public health risks and take part in equitable decision-making processes, whether it's permitting, funding, or other agency decisions. Thank you so much. I'm going to turn it over to Cody.
Thank you, Margaret. So where Margaret talked about environmental justice in the permitting context in the region, I'm going to zoom in a little bit and talk about some recently passed EJ legislation in Maryland that's related to conservation, infrastructure, and funding. And I'll build a little bit on what Devin talked about as well. And to start, EJ isn't limited to bills that say environmental justice in the title, but it really encompasses anything that affects equal protection in the environment. So I'm going to go over Maryland's definition of environmental justice. I'll give a broad look at some 2022 legislation that's related to environmental justice, and then I'm going to dive into 3 specific bills that passed this year. So to start with, this is a Maryland definition of environmental justice, and it's codified in the Maryland Environmental Code. Environmental justice means equal protection from environmental and public health hazards for all people, regardless of race, income, culture, and social status. So this is a broad look to give a flavor of some of the different areas that environmental justice touches in the legislation. You can see it touches everything from conservation to urban agriculture to food resiliency, as well as things like the EJ Screen tool that Devin discussed earlier. Today, I'm going to focus on 3 specific pieces of legislation. That's the Urban Farmer Assistance Program, the Conservation Finance Act, and the Urban Agriculture, Water, and Power Infrastructure Grant Program. So starting with the Conservation Finance Act, which Devin touched on earlier, this act is intended to improve water quality and achieve conservation and environmental justice goals. The act defines blue and green infrastructure and provides financing for both of those, and the act is intended to make it easier for Maryland landowners to participate in nutrient trading programs. So Devin went over this, but the act requires the Commission on Environmental Justice and Sustainable Communities to make recommendations to ensure that the Maryland Department of the Environment is progressing toward EJ goals, including safe drinking water. The act also defines blue and green infrastructure. So blue infrastructure is water-based and includes things like oyster reefs, and green infrastructure is land-based, and that includes things like rain gardens. Both of these infrastructure types are intended to improve the health and resilience of the environment, and the bill allows for funding of both of these types of infrastructure projects. So under the law, the law establishes technical assistance through 2 revolving funds that are situated as sub-accounts within existing funds. So under the Water Quality Fund, there is technical assistance available for long-term green or blue infrastructure projects. This technical assistance is for developing an application for financial assistance or for a financing plan. Eligible entities for this fund include publicly owned treatment works that primarily serve rural, small, or tribal communities, state, regional, interstate, or municipal entities, and nonprofits working with rural, small, tribal, or disadvantaged communities. And if you think back to when Devin was talking about overburdened communities, those are the communities that are disproportionately affected by environmental harms. Those communities are prioritized under this fund. Under the Drinking Water Loan Fund, there is technical assistance to small drinking water systems through planning or design phase grants. This fund is intended to address lead pipes, and eligible entities include drinking water system, small drinking water systems, multi-jurisdictional entities, and nonprofits working with rural, small, tribal, or disadvantaged communities. And again, overburdened communities are prioritized. And federal funds that are deposited into either of these revolving loan funds must be deposited into the sub-accounts. And finally, just to touch on nutrient trading, this act attempts to make nutrient trading easier for landowners. So under the act, the Maryland Department of Agriculture may not prevent cost share program participants from participating in carbon trading programs, and MDA and the Department of Natural Resources may enter into private partnerships to make carbon trading easier. So in the process of enacting legislation, members of the public may submit either written or oral testimony stating their position on the bill. And so for each of these pieces of legislation, I pulled a quote from the written testimony just to show how some of the stakeholders are viewing these pieces of legislation. This is a quote from the Maryland Farm Bureau, that the changes will also advance environmental justice and public health. So next I'll discuss a couple of bills affecting urban agriculture in Maryland. The Urban Farmer Assistance Bill addresses education and training, and the Urban Ag Water and Power Infrastructure Grant Program addresses infrastructure and funding on urban farms. And just to zoom out a little bit, urban ag encompasses all forms of agriculture that occur in and around cities. Maryland defines an urban area based on the U.S. Census Bureau's delineation of urban areas. An urban farmer is one who farms in an urban area. This is especially important in Maryland, where we have a lot of urban areas and a large urban farming population. So under the Urban Farmer Assistance Program, the University of Maryland Extension will hire 2 new extension agents. One will be focused on production methods and one focused on agribusiness management. And this bill is intended to assist with education and training of urban farmers. Each of these agents will perform research and education in their respective areas. For example, the agent focused on production methods could host crop planting demonstrations, and the agent focused on agribusiness could hold webinars about marketing products. And again, a quote from the testimony, this one from the Maryland Food System Resiliency Council. This bill will increase our food system resiliency in urban communities where residents are most affected by food deserts and food insecurities. Moving to the Urban Ag Water and Power Infrastructure Grant Program, this bill establishes both the grant program and a grant fund. Infrastructure particularly affects urban farmers who have to consider things like sewer lines when they're designing their farms. And the importance of this bill can be highlighted by something like the boil water notice that affected Baltimore a few weeks ago, really showing the need for urban farmers to have access to infrastructure resources. So this bill establishes a separate fund for urban ag infrastructure. There is money appropriated through fiscal 2027, and it can only be used for urban ag infrastructure grants and administrative costs. And again, this testimony quote is from Fair Farms, Maryland. It has the opportunity to bring in more urban farms with associated economic, environmental, and public health benefits. So as I mentioned in the beginning, environmental justice is a broad subject that encompasses more than just explicitly environmental justice or environmental bills. It also includes this broader notion of justice and things like access to infrastructure and funding, as well as inequity in the food system. And this is a framework that we should keep in mind as we continue to monitor environmental justice legislation that is becoming more prevalent. Thank you.
Everyone, are there questions from the audience?
Hi, Holly Porter, the Executive Director of the Delmarva Chicken Association. And I guess one of my first questions, and I have several, but I'll wait till later. But one of my first questions, I guess, that I'm really curious about is in the definition, it talks about protection from public health hazards, which is absolutely a must for all citizens, as I myself am a Maryland resident. I guess my question really goes to how science-driven is the discussion on public health hazards? Where is the tie to the science portion of public health and the other aspects as well, too?
Looks like they pun it to me. So at MDE, at least, where everything that we do, it's science-based. So for the mental public health hazards, absolutely. One of our administrations is called the Water and Science Administration. And so they're running everything, and it's way above my head because I'm no scientist, I'm a lawyer. But I know everything that we're doing is science-based. Now we'll talk about the Department of Health. So remember, MDE regulates the pipes in the ground, but the water coming out of the tap is regulated by the Department of Health. I know and it's usually done by the local health officers themselves. So the science is pretty straight on water. You know what should be in water and you know what should not be in water. And so it's really easy to make those determinations on the public health side. I think that's at least an attempt to try to answer that.
Is there a definition under the Maryland law of urban?
So under the two urban bills that I discussed, Maryland does define urban as the U.S. Census Bureau's delineation of an urban area. And that's literally how it's defined in the law. So it's based on the census tracts that have the population that Census Bureau would consider urban. I don't know off the top of my head. I can look that up and get back with you.
Any other questions? Do we have any online questions?
Holly, you have another question.
Raise your hand real high.
Colby Ferguson, Maryland Farm Bureau. A question that I've had and I've never really got a definitive answer on. when we talk about environmental justice and groups that are qualify under that, with agriculture, particularly crop agriculture, which is so subjective to the environment and to the volatile rain effects and things like that, would agriculture fall under one of those vulnerable communities, or is it just specifically talking about economic and urban?
Yeah, so I think that it would depend on the area. Sorry, yes. So from my understanding, it would, you would have to look to the definition of underserved communities and see if the population within that census tract meets those criteria. So generally, when we talk about environmental justice, we are talking about low income and racial minorities as, in terms of defining that a particularly vulnerable community that's been subject to those burdens. So I think it's possible that certainly that certain farms and agricultural areas meet those criteria under the, as far as the census data. And that's sort of the working guideline for defining whether a community meets that definition.
So according to our screening tool, our screening map, Salisbury is an area. So we don't call them environmental justice communities, folks. Let's get that right at the outset. The communities themselves don't want to be called environmental justice communities. So we call them communities with environmental justice concerns. Salisbury and the surrounding area is a community with environmental justice concerns. Chrisfield is a community with environmental justice concerns. Probably half of Somerset County is community of environmental justice concerns, both on race and on poverty, Colby. So the poverty is the number that you're seeing more, particularly along the Maryland-Delaware line in Caroline County, Dorchester, those sorts of things.
Thank you. This last question is for Cody and Devin. Does green infrastructure include solar installations and EV charging facilities? Is there grant or loan money available for these types of projects through the technical assistant accounts or urban ag, water, and power infrastructure grant programs? Can Cody please provide her, we'll provide your email afterwards.
I'll start by saying, yes, I can provide my email. And it might be on my bio on the website. I'm not sure. So the solar panels or the solar energy, I don't think is defined in the law under green infrastructure. I think that it would be included under the urban ag power infrastructure grants, but if you email me, I can double check that in the law and confirm that.
So EV, both solar canopy, solar charging has its own grant funding source from the Maryland Energy Administration. EV chargers have several funding sources, one through the Maryland Energy Administration, one and the Maryland Department of Transportation together. And there was the Volkswagen settlement dollars that went directly to EV charging stations as well. And so there's an annual grant program for EV charging stations and for the purchase to help subsidize the purchase of EV vehicle purchases.
All right. Well, thank you to our panelists.